A living will is a document that defines exactly what medical and life-saving procedures you refuse if you are mortally ill, with no reasonable hope of recovery. Usually, it states that you do not want to have your life artificially prolonged by modern medical technologies. It's a separate document from your last will and testament, but it must be executed with many of the same formalities. You should have a living will to make sure that your wishes are followed regarding your medical care at the end of your life, to relieve your loved ones of the burden of making end-of-life decisions without knowing your wishes, to enable your doctor to follow your instructions without being concerned about a medical malpractice suit, and to keep your private wishes on dying out of the probate court, where these disputes may otherwise end up. As part of the living will, most people direct that no heroic measures are taken to prolong their lives when they're in a persistent vegetative state, terminally ill, with no reasonable hope of recovery. Life support measures are typically refused, but the administration of pain medicine can be specifically allowed to the extent it alleviates any suffering. Specific treatments can be identified as desired or not desired. You can add instructions concerning chemotherapy, radiation, dialysis, antibiotics, or emergency surgeries to correct related or unrelated physical conditions. If you want to receive care in a hospice, that is something else you may wish to include in the living will. While there is an official form in the statutes, it's bare bones, and many people find that it doesn't cover all of their concerns. You have to be mentally capable of understanding what you're doing when you sign a living will, so you should do so prior to being in a crisis situation.